You for joining us for today's webinar. With me today are David Baker and Joseph Viviano from our private client group. Dave and Joe have put together a very full agenda highlighting recent cases and statutory changes impacting estate and trust disputes. Questions can be submitted through the Q&A function. Presenters will answer questions at the end of the presentation as time permits. And may chime in with answers throughout the course of this, the presentation as well. You should already have received today's slides, but they will be distributed again after the conclusion of the webinar. Very important, if you are requesting CLE credit in New York State, please listen at the end of our presentation for the validation code you will need to obtain CLE credit. Let's get started. Dave, what are the major topics you've seen courts and legislatures address in the last year?
The first couple topics we're going to go over are standing issues, standing to enforce or contest both private trusts and charitable trusts. The first topic we're going to talk about are a couple of recent cases that involve standing to enforce private trusts, and that typically involves standing to contest a document. And the developing issue here is this long-standing debate about whether or not prior legatees under wills and prior beneficiaries under trusts who've been cut out have the ability nonetheless to come in and challenge the document. Joe, why don't you talk about the two cases?
So today we're going to be talking about, with respect to standing to contest a revocable trust, two cases. One's out of decided by the Supreme Court in California, and the second was decided by the Court of Appeals in Florida. So in California earlier this year, the Supreme Court reversed an appellate decision that held an individual does not have standing to contest an amendment to an irrevocable trust that eliminates his or her interest in that trust. So really briefly, the facts here is that the settlor created the revocable trust and subsequently made amendments, restatements to that trust that eliminated the share given to one of her daughters. After the settlor died, the trust became irrevocable. The disinherited daughter petitioned to set aside those amendments to the trust, alleging that they were products of fraud, undue influence, and incompetence. So the issue that the California Supreme Court confronted was whether under California's probate code, which grants standing to a beneficiary of a trust, was whether or not the daughter was a quote-unquote beneficiary. So what the appellate court had decided before it got to the Supreme Court was that the daughter was not a beneficiary because she did not have a present or future interest in the trust, because she had been cut out. And so the California Supreme Court here reversed, though, for two reasons. First, it held that to determine standing, at least in California, you have to accept all well-pled allegations in the petition as true. In this case, the daughter pled that she would have been a beneficiary under the prior version of the trust and that the amended version of the trust was invalid. So therefore, she met the definition of beneficiary. Second, and as a broader matter, on public policy grounds, the California Supreme Court said that to hold otherwise would insulate those persons who improperly manipulate a trust settlor to benefit themselves. So the court did not want to go down that route. The second case in Florida is similar. In that case, the Florida Appellate Court held that notwithstanding an interim clause in a trust instrument, an individual who contested that an amendment to that trust that eliminated his or her beneficial interest still had standing during the pendency of the contest proceeding to sue the trustee for breach of fiduciary duties. And so again, briefly, the facts here, they're pretty similar. One of the decedent's children sought to invalidate this amendment to the decedent's will and revocable trust. If successful, they would have inherited everything by intestacy. And then while that lawsuit was pending, they sued the corporate trustee for an accounting. And then once they got the accounting, they filed a second lawsuit alleging that the trustee breached its duties. So the corporate trustee moved to dismiss that lawsuit on the grounds of standing, and the trial court agreed. But the appellate court reversed based on a somewhat unique Florida statute that said a trustee during the pendency of a trust administration cannot act, quote, in contravention of the rights of those persons who may be affected by pending litigation. And essentially what the appellate court here held was that that this standing recognized that, this statute recognized that contestants had a sufficient interest in a trust that warranted a grant of standing.
Let me just toss in a comment about Barefoot, the California case. When the California lower court decision came down, it was pretty widely and wildly criticized, justifiably, I think. But it wasn't actually as out of step as it sounds. It's only been the last 15, 20 years that the majority of states have recognized that a legatee or a beneficiary who's cut out in the process of progression of trust amendments and wills and codicils should have standing to contest. That was not always the case. In Illinois, for example, the will contest standing to a prior legatee was just granted by case law about 20 years ago. So it is something that the courts are sort of awakened to, but I think it was widely thought that the decision in Barefoot in the lower court was kind of tone deaf to the current trends, and I'm glad that the Supreme Court reversed it. The next topic we're going to jump into is a little esoteric, but it actually is roiling through courts all over the country. And that's who has standing to enforce the terms and provisions of a charitable trust that's been created by a person, but typically in an irrevocable transfer, so the grantor is no longer has powers over the document, is a beneficiary typically. And very often, for one reason or another, people with a relationship to the trust, sometimes people with no relationship to the trust, find something happening that they feel they need to or want to go to court about. And because in theory, all the people in a given state have the interest of seeing a charitable bequest fulfilled, the Attorney General always has standing. And when you look at the pleadings they file in these cases, they typically say the people of the state of California, ex-rel, Attorney General, so-and-so. The problem is that for various reasons, the AGs don't always get involved in these cases. And there's always been this debate about, can the grantor do something? Can anybody in the public go into court and enforce these documents? And one of the issues there, of course, is the kind of out of control standing issue. And many states have dealt with this by limiting standing to people with a special interest in the proceeding. There's no real agreement among the states on this. It's all over the place, and there's been a lot of development in the last year in several states. So I'm going to have Joe go over and both talk about the statutory provisions, the restatement, and the recent cases that have addressed this issue. Joe?
So if we go back to the 1950s and think about, historically, to build off what Dave just described, that the position taken by the second restatement of trust was that the settlor of a charitable trust, or the donor to that trust, did not have standing to enforce the trust. However, a person with a quote-unquote special interest did have standing, and what constituted a special interest wasn't clear back then, and as we're going to see in the cases that we're going to discuss now, it's still not entirely clear, and it's kind of being decided on an ad hoc basis. But just for as an example, I mean, it's generally understood that, for example, members of a single church could enforce a charitable trust created for the benefit of that church, and named charities who were named beneficiaries of that trust also had a special interest sufficient to confer standing. That historic approach has changed in most, but not all states, as we'll see. The UTC and the Restatement Third of Trust both confer standing upon the settlor of a charitable trust to enforce that trust. And they both continue to recognize this special interest doctrine. In the UTC, this is codified in section 405C, which says just very simply, the settlor of a charitable trust, among others, may maintain a proceeding to enforce the trust. And so in the last year, we've had 4 cases in UTC states that have grappled with who is included in the class of among others that have standing to enforce the trust. And the first case that we're going to talk about came out of Michigan. It was a decision by the Michigan Appellate Court in 2019. It was Lee Gassick as trustee of the James A. Bellamy Trust versus the University of Michigan Regents. And in that case, the successor trustee of a revocable trust, and who was also acting as the personal representative of the settler's estate, was found to have standing to enforce a charitable trust created under the settler's revocable trust. And so a lot of these cases are pretty fact specific, and it's going to be time consuming. So I'm going to go through these pretty quickly just so you get a flavor for them. But essentially in this case, a former professor at the University of Michigan in his revocable trust directed his successor trustee to transfer $3.5 million to the University of Michigan to form to endow a chair for a professor. The university accepted that gift, and for reasons we don't need to get into, subsequently did not abide by the terms of that gift. And so in responding to the successor trustee's action to enforce the terms of the charitable gift, the university said that the successor trustee did not have standing. And the trial court agreed and dismissed the case. On appeal, the Michigan Court of Appeals reversed and said that the among others language in the UTC, which Michigan has adopted, incorporates this special interest doctrine that Dave mentioned. Michigan, and this is the first of many illustrations of this principle, Michigan, like most states, did not adopt Section 405C of the UTC in wholesale. It made a fairly significant change, and it said that none of the settlers' heirs or the settlers' fiduciaries have standing to enforce the trust, the charitable trust, that the standing is personal to the settler. But notwithstanding that language, the Court of Appeals held that the trustee of the revocable trust still had standing. And so I guess this case is interesting for the point of view that at least in Michigan, courts seem to be broadly construing the standing doctrine, even in the face of a legislative directive to construe it narrowly. The second case, also from 2019, was decided by the Minnesota Court of Appeals. The facts are somewhat complicated, but essentially what happened was that as the defendant to a class action lawsuit agreed to pay $250,000 to endow a program at a university, the defendant paid the $250,000 to the plaintiff's lawyer, and then the plaintiff's lawyer actually made the transfer to the university. There was a dispute about who had standing to enforce that endowment. The trial court dismissed for lack of standing, and the Minnesota Court of Appeals agreed. So Minnesota, although it is a UTC state, did not enact Section 405C of the UTC at all, and thus applied the restatement second position to hold that a settler does not have standing to enforce a charitable trust. The third case is out of New Hampshire, and is also, again, like many of these cases, the facts are a little interesting. It involved a trust created by the founder of the First Church of Christ Scientists, and essentially the trust provided directed the trustee to generally promote that religion and support causes to that end. Yeah, but the trust did not name any specific beneficiaries. A branch church in Australia sued the trustee to enforce the trust. And again, on the question of standing, the New Hampshire Supreme Court agreed that the among others language in Section 405C of the UTC incorporated the special interest doctrine. That's the same result that was reached by the Michigan Court of Appeals. But it added a little bit of color to, it created a process for determining who has a special interest. And essentially, it adopted a 5-factor test known as the Blinko Test, or Blasco Test, that was advocated by some authors in 1993. And in this court, after applying that test, it determined that this unnamed potential beneficiary of this charitable trust did not have standing. And then in the last case, the 2013 case out of Pennsylvania, the court held that the executrix of the estate of a settler of a charitable trust does not have standing to enforce the charitable trust. I won't get into all the facts here, but I just would note that this is almost the exact opposite of the decision that was reached by the Michigan Court of Appeals, which held that the trustee and personal representative of a trust did have standing. And I guess the one thing that I forgot to mention about the Michigan case was that the court there also suggested that a trustee of a revocable trust might actually have a duty to enforce the terms of that charitable trust. Dave, have you ever seen anything like that anywhere else?
Yeah, I have. I've actually had to litigate that a couple of times, and the thought is you're the successor in interest to the grantor, and you'd have the same obligation, except now you're a fiduciary, and so you can't just flip a coin like the grantor could. You actually are a fiduciary to the grantor. The only two things I would add to this is keep in mind that these are all private actions, that this is a moot question if the Attorney General decides to come in, because the Attorney General always has standing in every state to enforce the charitable trust. So these are often what I call kind of grudge cases, where there's some particular grudge that some member of the family that set up the trust has. And that's why the courts dance around this issue, because frankly, sometimes these are kind of crackpot lawsuits. And the only other thing I'll add is that in the New Hampshire case, the Mary Baker Eddy is my great aunt, so I guess I would have standing to contest that charitable trust. All right, let's move on to no contest clauses. Before we launch into a couple of decisions, let me just put this in context. So a no contest clause, a forfeiture clause, a clause that says if anybody contests this document, their interest is gone. Those are now recognized in 47 of the 50 states. Vermont has not yet addressed the issue, and Indiana and Florida don't enforce interim clauses by statute. Everybody else does. And a little over half of the 47 states that do have one or two qualifications to enforcement. And generally those are described as good faith. If the person is pursuing the action in good faith, which is a subjective standard, what's in their head and their heart, then they won't be barred under the interim clause. And a number of states, a greater number of states, has something called a probable cause standard. That is a objective standard determined by the court. And that has to do with whether certain factors would give a reasonable person the reasonable belief that their challenge would be bona fide. If that's the case, then again, they don't enforce the interim clause against somebody who had probable cause to bring a contest. The thing about those two standards is they generate almost as much litigation as the interim clauses do, because more often than not, somebody who's potentially going to be barred will then try and make a claim that either the good faith standard, the probable cause standard, or both should shield them from being disinherited. And there are some recent cases that came down about that. Joe, why don't you kick them off?
We're going to talk about, I think, 3 or 4 cases involving the probable cause and or good faith exception. The first of those cases was decided by the Supreme Court of Nebraska. That's in re estate of Barger. And in that case, a widow executed 6 wills prior to her death. Each will became more and more favorable to one of her 5 children. One of the testator's children, who was completely disinherited, filed a petition to contest the will. What's somewhat interesting here is that the contestants' 3 other siblings, excluding the sibling who is alleged to have been unduly influencing his mother, they didn't stand idly by. They met with the contestant's attorney. They actually paid the contestant's attorney's fees. They testified in opposition to probate of the will, and they informally investigated various grounds for contesting the will. And ultimately, with respect to the substantive issue, the trial court found that the will was valid. And so there's really only 2 issues that were on appeal. First was the assistance that the contestant siblings gave sufficient to trigger the no contest clause. This was not a broad no contest clause. It didn't include language that you might typically see that says indirectly contest or aid or abet the contestant. It just said files any proceeding to contest the will. The second issue is whether or not the contestant and his siblings had probable cause for the challenge. So with respect to the first issue, the Supreme Court of Nebraska, without much analysis, said that a no contest clause may be violated when the person restrained by the clause voluntarily instigates or aids another person in his or her attempt to contest the will. So I guess the takeaway here is that even if you have a fairly generic, narrow, no contest clause, it might be the case that it covers more than you think it does. And with respect to the second issue, the court found that the contestant and the siblings had probable cause for the contest for 5 reasons. They relied on advice from counsel. The testator was in poor health. The testator's amendments, evidence, a gradual influence from the influencer. The scrivener, also who represented the testator, also represented the person who benefited from the amendments to the will. And under a deferential standard review, the courts, upheld the trial court's finding that there was probable cause here.
Joe, let me just add on the indirect sort of aiding and abetting issue. That's actually gone up to the Supreme Court in a couple of states, in particular in Arizona in the Stewart case. And there, the Arizona Supreme Court held that not only can a person be disinherited because they are indirectly involved, basically aiding and abetting another person who's bringing the formal contest, but they went so far to hold that sitting for an interview with the plaintiff's lawyer would be an aiding and abetting that would trigger the interim clause. And they had to draw the line in the sand and say giving compelled testimony under subpoena would not. But they came to that ruling because their ruling was otherwise so broad that they felt they had to at least carve out compelled testimony. So the courts that have looked at the aiding and abetting clause issue, with or without specific language in the interim clause, have all held that you can be disinherited simply by helping somebody else bring a will or trust contest if you happen to be a beneficiary. I'm sorry, Joe, go ahead.
So the second case involving no contest clauses was out of Mississippi. It was Rusa versus Rusa, this 2019 Court of Appeals case. And there, a widow executed a second codicil to her will, leaving most of her estate to one of her 4 children. The testator's son attempted to admit the testator's will without the second codicil, but the testator's daughter, who benefited from the second codicil, then proceeded to submit the second codicil for probate. And after a trial, there was a contest, a question as to whether or not that codicil was valid. And after a trial, a jury found that the second codicil was actually invalid. And so there were 2 questions here. The first was, did the daughter's attempt to probate the second codicil trigger the no contest clause? And what the daughter argued here was that she didn't actually contest the will. She merely submitted the second codicil for probate, which she argued that she had a legal duty to do. And then the second issue was, assuming that the daughter did contest the will, did she still have probable cause for doing so? And so what the Court of Appeals here held was that even though it seems somewhat receptive to the argument that the daughter may have had a duty to probate the codicil to the will based on Mississippi law, which makes purposeful concealment of a will a crime, it nevertheless violated the terms of the no contest clause that was in the will, which applied to any proceeding to prevent any provision of the will from being carried out according to its terms. So that only left the second issue for decision, which was whether or not the daughter had probable cause. And to me, it seemed like the probable cause here finding was a little bit thin, but essentially the court said that the daughter had probable cause because the second codicil was drafted by an attorney. The daughter was not present when the testator executed that codicil, and that the execution of the second codicil was not a secret.
Joe, let me just add something about that case and that holding. Much impressed as I am with the Mississippi court's faith in lawyers in general in that holding, in roughly half the states in this country, presenting any document or to claim that it's a subsequent document that revokes the prior will, or just arguing that the will has been revoked, is by statute a will contest. And so that's not, that holding and that discussion is not as outlandish as it kind of sounds at first glance. It typically is a will contest when you want to argue that the will that's being offered for probate has actually been revoked, notwithstanding the statement in the petition to admit the will that it has not.
So then we get.
Sorry, just a quick question. Would that be different if she had just filed the codicil, do you think? Maybe that's for Joe, but as opposed to filing it and petitioning to have it admitted and as part of the will and admitted to probate?
Well, in all 50 states, if you are a person in possession of an original will, you have a duty to file that will, and in about 42 of the states, it's actually a misdemeanor if you don't. So I do think it would be difficult to take any sort of action against somebody for failure to actually file what appears to be an original will with the clerk of the court. It is the petitioning to admit it, to contravene a will that's already in probate or being offered for probate, that effectively turns into a will contest. So I think filing it would be a non-issue, whereas failure to file it with the court might actually put you in jail.
Thanks.
Speaking of jail, the next decision out of the next case we're going to discuss, which is the first of two decisions out of the South Carolina Court of Appeals. It didn't involve jail, but it's probably something pretty that I think most people here will agree it was a pretty bad result. And so in this case, following the settler's death, her daughter began to act as successor trustee. The terms of the trust directed the trustee to sell the trust property, quote, as soon as practical following the settler's death, and to distribute the sale proceeds to the daughter's stepfather. So the daughter acted pretty reasonably here. The property, the trust property, was sold within a few months following the settler's death, but the daughter did not distribute the sale proceeds immediately because the creditor claim period against the Rev Trust had not yet expired. And the stepfather, having apparently not a great relationship with his stepdaughter, couldn't wait and filed a breach of trust action against his daughter for not distributing the proceeds. And then the daughter then argued that his actions trigger the no contest clause. So there were essentially two issues on appeal. The first was whether the stepfather had probable cause to commence the breach of trust action. And the second was, more interestingly, whether the trustee actually committed a breach of trust by failing to distribute the sale proceeds before the expiration of the creditor claim period. With respect to the first issue, the court, didn't spend a lot of time analyzing it. It just said essentially that the stepdad had probable cause based on the expert testimony of a professor who said that this was in fact a breach of trust, and the terms of the trust which directed the sale proceeds to be distributed as soon as possible. The second issue I think is more interesting here. Keep in mind, this is a published decision out of the South Carolina Court of Appeals, and it held that the trustee in fact did breach her fiduciary duties by not distributing the sale proceeds before the creditor claim period expired. And to add insult to injury, awarded the stepfather attorney fees for bringing the breach of trust action. And in reaching this decision, the court seemed to adopted the expert's opinion that the trustee could not have been personally liable to a creditor for if she distributed the trust property before the claim period expired, because the creditor could always collect the proceeds from the sale father. The court didn't seem to take in account for the fact that the trustee might be jointly and severally liable, and the stepfather might not have had the assets to satisfy any creditor claim. And so it's a pretty terrible decision. There's one other thing I think that's interesting about this. The opinion doesn't discuss or include the terms of the no contest clause, but obviously it applied to administrative proceedings, actions taken against the trustee to enforce the trustee's duties, not contest the provisions of the trust itself. There's, I think, Dave, you can probably elaborate on it, but it's unclear in most states whether or not those type of no contest clauses will be enforced.
Typically, courts will not enforce an interim clause when the issue that's being contested is whether or not a fiduciary has properly accounted or otherwise properly administered an estate or trust. So that is an unusual holding. Joe, why don't we skip to the Gowdy, the Wyoming case, because I think we're getting a little behind. So let's jump, because I think that the issue of decanting, the world, the state and trust world seems to me to be drunk on decanting. Everybody wants to decant everything, and I think it's interesting. The Gowdy case is interesting for the application of an interim clause in a decanting case.
So the Gowdy case is a decision by the Wyoming Supreme Court, and just really briefly, the facts are that the primary beneficiary of a trust filed an action alleging that the trustees/scriveners of the trust violated various duties, but more importantly, asked the court to quote unquote decant the trust to repair issues during drafting errors. And with this decanting, all it really asked the court to do was eliminate a provision of the trust instrument that required the trustee to be a corporate trustee with a capitalization of at least $100 million. And so the trustees in response argued that the beneficiary's actions triggered the no contest clause, which was triggered if by any beneficiary who sought to obtain adjudication in any court proceeding that the trust provisions were void or otherwise seek to nullify, set aside, or modify the trust. And so what I think is kind of interesting here is that everyone on this call knows that a beneficiary can't decant a trust, and the Supreme Court of Wyoming recognized in this opinion, it stated that a beneficiary does not have authority to decant a trust from which they stand to benefit. Nevertheless, and notwithstanding that the beneficiary's request was arguably invalid, the court held that the no contest clause applied to any proceeding and therefore held that it was triggered.
And let me just, because we're going to flip now to broader cases involving decanting, I'm going to assume that most of the people listening in or reading this know what decanting is, but just briefly Decanting is relatively new, the last 25 years. It involves an irrevocable trustee taking the trust property and using broad discretion or narrow discretion under the document to distribute all the trust property into a new trust with somewhat different provisions. And I've always sort of thought that practitioners are kind of drunk on this idea, and that sooner or later the IRS is going to wake up to this and say there's no such thing as an irrevocable trust anymore, and therefore all the great tax benefits that you folks get from irrevocable trusts are out the window. And one of the things that these cases that we're about to discuss talk about is whether or not there are limits on what otherwise appears to be an express statutory power to decant by a trustee of an irrevocable trust. So, Joe, why don't you talk about that in these decanting cases?
So the next case involving decanting was also decided by a state Supreme Court, this time by the Supreme Court of Nevada. And it involved essentially, briefly, the facts were husband and wife created a charitable trust. Following their divorce, the wife petitioned the court to order the trustees to decant the trust into two separate identical trusts. One trust, the husband would be the trustee of, and the other trust, the wife would be the trustee of. And the trial court granted the order to decant the trust over the husband's objection. This went up to the Nevada Court of Appeals, the Nevada Supreme Court, and the court first noted that it wasn't clear whether a charitable trust could be decanted under Nevada law, but then it proceeded to decide the question anyway and say that essentially the trial court erred here by what I interpret the opinion to be on the basis of that the trial court improperly substituted its judgment for that of the trustees. And Nevada's decanting statute expressly says that the power to decant is held by the trustees. So I think one of the interesting parts about this case here is that, to go to Dave's point that everyone is drunk on decanting, there's other ways that the same result could have been reached without a decanting. You could have asked the court possibly to divide the trust and then remove one of the trustees from one trust and one of the trustees from the other trust to reach the same result. So this is the second case in the last year where the highest court of a state said that decanting wasn't appropriate here. And it might be, it looks at least like we're finally seeing some pushback. As Dave mentioned, it's kind of like, people are thinking of decanting as a hammer and every problem that they see is a nail. And so that, I don't know, Dave, do you have anything else to add on that case?
No, I just think we're going to see more decisions as people try more expansive and creative ways to use decanting, and parties and courts push back on it. Why don't we flip to that, to the Helton case, the Ohio case, because I think it's interesting in the context it arises, which is unlike anything I've ever seen before.
This Ohio case is Helton versus Fifth Third Bank. It's a 2009 decision by the Ohio Appellate Court. And essentially, at its face, it's a failure to diversify case. This trust was created in 1939. It was almost entirely invested in a privately held company. There was repeatedly, the bank told the beneficiaries that they should be diversifying, but the beneficiaries did not want to do so. In 2008, the bank had a conference call with the beneficiaries where it again discussed the trust's excess concentration in the closely held stock. And then, like most of these cases, the closely held company filed for bankruptcy eventually, and the beneficiary sued for failure to diversify. So the issue on appeal was whether or not Ohio's statute of limitations foreclosed the claims brought by the beneficiaries. And so in order to understand this case, you've got to know this part about Ohio's law. its statute of limitations is for breach of trust actions is either 2 or 4 years. It's 2 years if a beneficiary sent an accounting or report disclosing the potential claim, and it's 4 years absolutely, regardless of whether or not accounting is sent, if the beneficiary from the date that the beneficiary knew or should have known about the breach of trust. And so essentially what the Court of Appeals found was that the beneficiaries knew or should have known about the failure to diversify in 2008 when this conference call was held. They didn't file their action until more than 4 years later, and therefore it was barred. The other interesting part about this case, however, is that the beneficiaries, in response to the statute of limitations argument, argued that the trustee continued to breach its duty by failing to diversify the assets, and that breach continued up until the day that the petition to hold the trustees liable for the breach of their duties was filed. And the Court of Appeals rejected that argument and declined to adopt that same position that was taken by the U.S. Supreme Court in a 2015 ERISA case. So, Dave, how does this case compare to some of the other failure to diversify cases that you've seen?
Well, I think the thing that's unique about this case, and maybe fiduciaries should all be moving to Ohio, is that this is the only case I'm aware of where you can have a statute of limitations running against the beneficiaries without an accounting. Obviously, they had a shorter statute in Ohio if there was an accounting issue, but this 4-year knew or should have known standard, whether or not you got an accounting, is either nominally or expressly contrary to the way this works in virtually every other state. In fact, if you think of the Dumont case where in New York, where a very long-standing diversification fight that went on for decades was eventually tossed because the beneficiaries failed to timely object to the concentration when they got an accounting. And that's the way it works in most other places. You wouldn't have any statute of limitations on breach claims in most courts, in most states, until there's an accounting that discloses the breach and a cutoff is set by the judge hearing the accounting proceeding, or there is a statutory cutoff for any claims made that, again, in most states under their Trust and Trustees Act, runs from the date the accounting is actually issued. So in that sense, I think that aspect of the case is sort of an outlier. Joe, let's, in the interest of time, let's skip the statutory cases on removal of fiduciaries and go to the Slayer statute cases.
So very briefly, there were 2 new Slayer statute cases decided in the last year. One was decided by the Supreme Court of Colorado. The second was by the Illinois Appellate Court.
Let me just put the context, because I don't know that everybody on this call will understand what a Slayer statute is. Every state of the union has what we call a Slayer statute, except New Hampshire for some bizarre reason. And I guess they don't want to discourage killing people for money. And the purpose of the Slayer statute is to prevent somebody who causes the death of a person from inheriting or receiving any property by will, by trust, by insurance, by any way they can by reason of the death. It's obviously a policy-driven thing, and they're typically construed as broadly as possible because nobody likes a killer, and the courts are doing what they can to disincentivize people killing people to get money. In that context, I find these 2 cases kind of interesting. Joe, why don't you?
Yeah, so these cases are interesting because they buck that trend. In both cases, the courts held that the Slayer statute didn't necessarily apply here. In Colorado, what happened was that a husband received life insurance proceeds from following the death of his wife. 3 years later, he was charged with his wife's murder. And in the murder defense trial, he used those life insurance proceeds and he paid a $500,000 retainer to his law firm. And the guardian ad litem for the daughter of his mother filed an action seeking essentially to freeze that retainer and prevent the attorney from disposing of the assets. And based on an exception, a good faith purchaser exception in Colorado Slayer statute, the Supreme Court of Colorado held that that even not only could an injunction not be issued, but that those funds that were paid to the attorney as a retainer, even though not yet earned, were exempt from recovery under its Colorado Slayer statute. The second case out of Illinois is factually interesting. We'll skip the facts and just say that the defendant in that case was charged with, actually pled not guilty by reason of insanity to first-degree murder of his longtime girlfriend. The trial court in the criminal proceeding accepted that plea, and on appeal to the Illinois Appellate Court in a separate civil proceeding involving the Slayer statute, the question was whether or not the defendant was collaterally estopped from arguing that he did not trigger the Slayer statute by his actions. In Illinois, you have to have an intentionally and unjustifiably caused the death of another for the Slayer statute to be triggered. Illinois also creates an irrebuttable presumption that you intentionally and unjustifiably cause the death of another if you're convicted of first or second degree murder. That presumption didn't apply here because of the not guilty by reason of insanity plea. But the trial court held he was nevertheless collaterally estopped from arguing. The Slayer statute didn't apply, and the appellate court reversed that and remanded after finding that the elements necessary to accept a not guilty by reason of an insanity plea for first-degree murder are different, or could be different, from the elements necessary to trigger the Slayer statute.
You know, there are a couple states, Florida in particular, that carve out of their Slayer statute people who are found not guilty by reason of insanity. That's by no means the common occurrence. Most of the Slayer statutes would apply as long as you intentionally and without justification cause the death, and typically that's viewed to be not just a lower burden of proof, but a much lower standard than motivated murder or manslaughter. So the Illinois case is frankly kind of surprising given the other Illinois cases. Joe, let's go to the claims on revocable trusts, the Michigan case.
So this is a case decided by the Sixth Circuit applying Michigan law. It's the latest in 10 years of litigation. I think there's 5 appellate decisions involving this case, but essentially the facts are simple. The settler of a trust individually and as trustee of the trust guaranteed a $500 million loan to his company, which was an auto supplier. The settler personally guaranteed $50 million of the loan, and the trust had an unlimited guarantee. The company defaulted on the loan. The settler paid $50 million to the lender pursuant to the guarantee. But then the settler, as trustee of his trust, contested the lender's right to enforce the remaining $450 million guarantee that he issued in his capacity as trustee. So the Sixth Circuit wasn't very sympathetic to the trustee's argument that this is a revocable trust, he owns the assets, and therefore he can't, the lenders couldn't collect on the guarantee. Basically the court said, look, under Michigan law, a trustee of a trust can enter into enforceable contracts, and that's all that happened here. Despite a request from the court, the parties didn't brief the issue of whether the settler could simply revoke the trust to avoid paying the bank. It's not clear why they didn't. There might be other reasons for that, why it wasn't an issue. I practiced in Michigan for a number of years. This is the only case out of that jurisdiction that I've seen applying this result. Dave, is there law in other states on this?
Well, I think this is kind of an outlier that may be driven by the unique facts. In most states, and this is true certainly in Illinois, New York, I think California too, you can't use a trust to guarantee or indemnify third-party debt obligations unless there is express language in the trust document, empowering the trustee to do that, because that effectively is creating a third-party beneficiary status to somebody that the grantor didn't name as a beneficiary. It's different than just a power under the trust document to encumber assets or incur debt, because that's typically viewed to apply to property that's in the trust and beneficial interests that already exist. So in most states, you probably wouldn't get to this stage just because it's unusual to see a trust document that has that sort of express language in it. Joe, let's do the arbitration case, because I think that runs counter to a lot of current trends. So I think that's an important case to talk about, the Texas case.
So this is a decision from 2019 by the appellate court in Texas. And briefly, what happened there was that the trustee of a trust established a brokerage account. Like most brokerage accounts, in order to open it, the trustee had to sign an account agreement. And this account agreement said that all parties were required to submit any controversy relating to the account to arbitration. A beneficiary of the trust, through her representative, sued the trustee for breach of trust, and derivatively also sued the broker for aiding and abetting the trustee. In response, the broker attempted to compel arbitration of the Federal Arbitration Act and argued that the beneficiary is bound by the arbitration agreement signed by the trustee under 4 different theories. In a fairly detailed opinion, the Court of Appeals held that the beneficiary was not bound by the arbitration agreement under any of those theories. And what's kind of surprised me here is that, at least in Texas, there's a series of cases that hold the exact opposite, that a beneficiary is bound by those type of arbitration agreements. And I won't get it's really fact specific, but I think that's the main principle here.
Yeah, and I would add that this definitely is running counter to trends, not just to the existing Texas law, but in all of the states, that's now 11 going on 12, I guess, that have faced the question of whether or not an arbitration clause in a trust, let alone in a trust-related matter, are enforceable. They've all said yes, with the exception of California, which has said yes for everything except an actual trust contest or will contest where no distribution has been made. So this does run kind of counter to what I think is the current trend. Let me address a couple questions that came up in Q&A. One was whether or not there's materials that have case sites. The flip book that was distributed ahead of time and will be distributed again and posted afterwards does have case sites for all these things that we're talking about. And then there was another question about whether or not we'd seen a case where, because property had been decanted from one trust to another, it exposed an otherwise spendthrifted trust to creditor claims. I haven't seen that. I suspect if it was out there, I would have seen it by now. I think most cases that have interpreted decanted trusts, and in fact many decanting statutes, make it very clear that the administrative provisions that are in the landing trust are still effective. Of course, if you decanted to a trust that wasn't spendthrifted, there would be a question there, but there's been a lot of discussion about whether or not a spendthrifted trust can be decanted, and if it can be decanted, must it be decanted to another spendthrifted trust? I don't think that question's been addressed directly by a case really anywhere. There's another question about whether or not a non-judicial settlement agreement could potentially trigger a no contest clause. Again, I haven't seen that. I would be surprised to see it, only because they are typically statutorily sanctioned, and it's hard to imagine a court basically punishing people for taking advantage of something that the statute allows them to take. I think the more effective way for people who don't want a non-judicial settlement agreement to modify their documents is not to rely on an interim clause. In virtually every state, if you can opt out of these sorts of things. And if you have a provision in your document that says no matter what, you can't take advantage and modify this document through a non-judicial settlement agreement, I think that would effectively, in most jurisdictions, block that. But I don't think it should or would trigger an interim clause. And I don't know, we don't have a whole lot of time left. Let me just say that there's other cases in the flip book, including an interesting case about state bankruptcy protection, sort of preempting federal bankruptcy protection for an inherited IRA. That's a Rhode Island case. And then in the flip book that we sent around, there's been a fair amount of activity under uniform law adoptions. Several states during the last year adopted the Uniform Trust Code, Illinois, Connecticut, and Colorado. A number of states have adopted the Uniform Directed Trust Act and the Trust Accounting Act. Those are all listed in the materials that we circulated, and I think we are out of time. Jared, you want to do your CLE thing?
So thank you, everybody, for joining us today for another in our series of Trust and Estate Controversy virtual forums. Those of you in New York, please remember to add the phrase Purple 11, PURPLE 11, to the evaluation form that we will be circulating shortly after the conclusion. Please fill out the rest of the evaluation form, whether you're in New York or anywhere else, and tell us what we did well and what we could improve. And we look forward to seeing you at the next forum presentation, which is our offshore roundup on September 24th. Thanks again.